Hello and welcome to Connected With Latham, where we discuss ideas, legal developments, and business trends shaping the global economy. This is the 13th episode of the Latham & Watkins Drug Pricing Series, and I'm Chris Schott, a partner in the Healthcare and Life Sciences practice in our Washington, D.C. office. I focus my practice on all things market access, and that includes manufacturer compliance related to the Medicaid Drug Rebate Program, Medicare Parts B and D, and the 340B Drug Pricing Program, as well as, of course, implementation of the Inflation Reduction Act. Joining me is Daniel Machado, an associate in our Washington, D.C. office.
Hey, Chris, it's great to join you again.
Thank you for joining the podcast today. In each episode, we focus on a specific topic that is relevant to drug pricing or the pharmaceutical industry or the healthcare industry. And after discussing the substance, we ask the question, which Olympic sport is it like? And we have the list of Olympic sports here to see which most resembles the topic in terms of strategy, complexity, or frankly, level of conflict. So, Danny, what is our topic for today?
Today, our topic is the Medicaid Final Rule, which CMS issued on September 20, 2024, and which is entitled Medicaid Program Misclassification of Drugs, Program Administration, and Program Integrity Updates under the Medicaid Drug Rebate Program, which was also a rule meant to implement a law passed back in 2019 entitled the Medicaid Services Investment and Accountability Act of 2019.
Right, and maybe let's start with a little bit of background. That statute, which we'll abbreviate as MSIAA, as you said, was passed in 2019, and it focused on adding enforcement authorities to CMS under the Medicaid Drug Rebate Program. And to set the stage a little bit, one thing that prompted the legislation was the significance of drug categories in the Medicaid Drug Rebate Program. So as we know, there are three categories: single source, innovator multiple source, and non-innovator multiple source. And the first two, S and I drugs, are so-called brand drugs, while the third category are N drugs, which are essentially generic drugs, to simplify it a little bit here. Those categorizations matter because the rebate formula differs for S and I drugs as opposed to N drugs, and the brand drugs, S and I drugs, are subject to a higher Medicaid rebate than the N drugs. And Congress was concerned that manufacturers might be classifying their drugs as N drugs and paying the lower rebate, when in fact the drug should have more appropriately been characterized as an S or I drug. And there was a particular settlement with a particular company on a particular very popular product that prompted all this focus by Congress on this issue. And essentially Congress felt that CMS needed additional authority to step in case there were drug misclassifications, and that's why Congress enacted this MSIAA. So CMS in 2023, quite a bit later, decided to implement some of these enforcement authorities that the MSIAA gave the agency in this proposed regulation. But interestingly enough, CMS went far beyond the scope of implementing what the MSIAA had provided and touched on a number of other areas in the Medicaid Rebate Program not really connected at all with issues raised by the MSIAA. Danny, what were some of these other topics that CMS addressed in the proposed rule?
Yeah, so let's talk about what CMS initially put on the table with this Medicaid rule back in May of 2023. They came out swinging, really, with some pretty bold proposals. We're talking about redefining what counts as a manufacturer to potentially rope in more companies under the Medicaid rebate umbrella. They also floated the idea of a new vaccine definition, which could have shaken up how certain products are treated in the program. One of the big ones was this concept of stacking discounts for best price calculations. Essentially, they wanted manufacturers to combine or stack discounts to different entities, which would have seriously impacted pricing strategies. Oh, and they proposed this drug price verification survey, kind of a shame list for high-cost drugs. They also wanted to tweak how drugs are classified as covered outpatient drugs, potentially expanding what's subject to the rebates. And there were some proposed changes to manufacturer audit timelines and how audit or internal investigations are defined for purpose of restatement. So there was a lot to unpack, and as you can imagine, it stirred up quite a bit of controversy in the pharmaceutical industry.
Yeah, so a really broad array of topics that CMS just decided to connect with this hook of, oh, we're implementing MSIAA, let's jump on a bunch of other topics. So maybe what we'll do next is kind of tick through some of these anyway and talk about what they are. And I think it's probably best to start with the ones that didn't make it into the final. So you already teed up best price stacking. So this is the interesting question to figure out best price, right? The lowest price made available in the quarter. If different discounts go to the same customer on the same unit, those discounts get combined together to figure out the truly lowest price. This is what's known as best price stacking. And so the longstanding approach in the industry has been that stacking only is an issue if it is, like I just said, the same unit to the same customer. CMS in its proposed rule tried to implement something known as follow the pill, where it would have been enough to be the same unit, regardless if the customers were different. And it would have been required of manufacturers to stack all the different discounts that this one unit of the drug experienced or engendered in its journey through the supply chain. That would have been the stacking requirement. So a significant departure from 30 plus years of practice and CMS approaches. And Danny, how was this communicated that the best price stacking wasn't going to be in the final rule?
So, yeah, with regard to the stacking, Chris, as you highlighted before, CMS did not finalize its proposed change, which was welcome news to the industry. As you mentioned, CMS had given as an example, which the industry thought quite far-fetched, that a manufacturer provided a discount to a wholesaler and then a rebate to the provider who dispenses that drug unit, and then say another rebate to the insurer who covered that drug unit. Then they had concluded that best price was going to stack all of those discounts associated with that final price. Quite a departure from precedent, and so interesting and welcome news to the industry that this was not finalized.
Yeah, and curiously, this was one where CMS informed the industry before the final rule was issued. So back in May of this year, CMS, on its own volition, sort of issued a statement that basically said, FYI, we're not finalizing that part of the proposed rule. So we found out that this piece was not going to make it in advance of the final rule actually being issued. Danny, you also had mentioned the manufacturer definition. Also an interesting point. Back in the early days of the program in 1995, CMS issued a proposed rule that was never finalized that would have been the first comprehensive regulation of the Medicaid drug rebate program. And in that 1995 regulation, CMS proposed a broad manufacturer definition to basically loop in sister companies, parents, joint. So essentially the corporate control definition, right? Under the same control with, controlled by, et cetera. Like I said, that was never finalized. Since then, we've had a manufacturer definition in the statute. There's been a longstanding regulatory manufacturer definition. So here in the proposed rule, CMS was trying to go back to the 1995 standard. And the concern or the policy goal of the agency was to make sure that if one entity joined MDRP, that all related entities would have to enter as well. So this would have posed a problem for, let's say, hypothetical construct where there's an ultimate parent company overseas possibly with two completely unrelated entities in the United States. Under this proposed manufacturer definition, it would have been potentially a challenge to have one of those U.S. entities in the program and one outside, although they were completely separated and unrelated in the United States, just happened to be owned together by some ultimate parent up the chain. So CMS also stepped away from that definition. Danny, you mentioned the so-called price verification survey. Tell us about that and how that fared.
Yeah, the price verification survey, which was essentially a bit of a shame list in a way for manufacturers in the Medicaid program, and in a way trying to expand what the Inflation Reduction Act was doing in Medicare through statute, but adopting in a regulatory manner something that Medicare has authority to do in the Medicare world, but CMS does not have authority to do it in Medicaid. So once again, the industry was pleased to see that this drug price verification survey did not make it into the Medicaid final rule.
Yeah, this was an interesting one. I think just like you said, sort of, CMS has these two parts of the house. There's the Medicaid side, the Medicare side, and we've had this experience that they don't necessarily communicate all that much. And so here it really kind of starts to look like on the Medicare side, right? Inflation Reduction Act gave CMS all these powers with drug pricing and negotiations. It almost felt like the Medicaid side felt left out and kind of wanted its own, pressure point on drug pricing, and so suggested that there would be this published list of the most costly Medicaid drugs. Like you said, probably sort of with the idea of having a shame list there. So that also did not make it in. The last one that didn't make it, what we'll talk about, is vaccine definition. The covered patient drug definition, which we'll talk about in more detail in the Medicaid statute, does not include vaccines. It excludes vaccines. And CMS here in the proposal was trying to slice and dice that very carefully and say, well, there's traditional vaccines, what we all think of as vaccines, one shot and you're immunized, versus these therapeutic vaccines, which boost immunity but have to be administered periodically, ongoing over time. And so CMS was trying to craft this bifurcated vaccine definition where the traditional vaccines would be out of Medicaid like before, but these so-called therapeutic vaccines would be rebate eligible. So despite the fact that they are vaccines, they would have triggered a Medicaid rebate, and CMS did not finalize that proposal. So what all these have in common, which we'll talk about a little bit later in the podcast, is they are significant departures from the statutory foundation, and we'll talk about how that may have played into CMS's calculus. So maybe more importantly, let's turn to the proposals that did become final. And I want to start with the misclassification of drugs and what CMS can do. After all, this whole regulation was allegedly prompted by the MSIA, which is all about drug classifications, product information. So Danny, tell us a little bit about what CMS did here, how it is implementing its newfound enforcement powers.
Right. Exactly, Chris. So to your point, this goes back to the MSIAA law of 2019, which really established requirements with respect to misclassified drugs under the Medicaid drug rebate program and associated civil monetary penalties. So in the proposed rule, CMS stated that misclassification of a drug would occur when a manufacturer reports a drug category, which, as you explained in the beginning, single source, innovator, or non-innovator multiple source, the SIN drugs, or drug product information that is not supported by the statutory or regulatory definitions. CMS had proposed, and we see that they have finalized actually, a process and a timeline for notifying manufacturers of these misclassifications and a process for correcting them. So CMS has said in the proposed rule and has finalized that 30 days from the time that CMS notifies a manufacturer needs to correct that data. 30 calendar days. That's not a lot of time. And notice needs to be made electronically in writing. Then 60 days from the time that CMS notifies the manufacturer has to pay any additional rebate to the states that is due. That's 60 calendar days. Again, not a whole lot of time. And if the manufacturer does not abide by this quite strict timeline, CMS would have the authority to go in and, as necessary, correct the misclassification. They could suspend the misclassified drug from the rebate program. They could assess civil monetary penalties and impose other penalties that are available by statute, so quite severe penalties. And as we have seen in this final rule, CMS largely finalized these provisions as they had proposed.
Yeah, maybe it makes sense here to highlight a little bit how the final rule is actually different from the statute or going beyond the statute. So you mentioned the 30 and 60 days. That is nowhere to be found in the statute. The statute says, secretary must notify the manufacturer. Manufacturer needs to then come into compliance. There is no time period imposed there. So CMS is very aggressive here with 30 and 60 days. And if you are a manufacturer that has had to deal with reclassifications for whatever reason, I think everybody knows that 30 days to reclassify, 60 days to make all payments is extremely unrealistic. The other, I think, highlight here is that its definition of drug product information is exceedingly broad. So the statute, the MSIA, was focused mostly on drug category because it's the drug category that impacts the Medicaid rebate. That's what Congress is really focused on. In its final rule, as in the proposed rule, CMS is painting with a broad brush and this basically defining drug product information as almost any product attribute. And so, as you probably know, manufacturers go into the MDP system, which is the online portal for price reporting, and they have to enter their products, and for each product, fill in a number of fields with product attributes, not just drug category. And so here, CMS is expanding its enforcement authority to encompass other product attributes, not just drug category, to a very broad definition of what is drug product information. One thing that the statute provides, so it's not a CMS invention, is the ability of the secretary to go and change the drug category. So that's a pretty major departure because in drug pricing world, we, the manufacturers, report our information. If it's non-compliant, then we face penalties and enforcement, but the decision what to report, how to report is left up to business. And that was intentionally set up this way when these programs were enacted. So here we have a departure from that where the government will come in and will change your reported information as the secretary deems fit. So crossing a line here and moving away from the price supporting paradigm in a sense that's been established for a long time. Let's mention one other thing briefly, restatements. As we know, there's a 3-year restatement window in Medicaid where the manufacturer can, and in some cases must, go and restate and best price other data for 3 years. The restatement in that 3-year window does not require government involvement. It's the manufacturer on its own volition going in and restating. There's also a possibility of restating beyond the 3 years, but those restatements are upon request to CMS. And there's an enumerated list of reasons for restating outside the 3-year period in the current regulation. And one of those is as a result of internal investigation. And CMS here is changing the definition, or for the first time actually defining what it considers an internal investigation. Danny, what was the final rule provision there?
Great one, Chris. And here CMS is defining internal investigation as a manufacturer's investigation of its AMP, or average manufacturer price, best price, customary prompt pay discounts, or nominal prices that have been previously certified in the rebate program. That results in a finding made by the manufacturer of fraud, abuse, or violation of law or regulation. Now, that was in the proposed rule. What CMS has done in the final is that they basically finalized that definition of internal investigation, but they added the term possible. So CMS has added this possible qualifier right before where it says fraud, abuse, or violation. So now in the final, it reads a finding made by a manufacturer of possible fraud, abuse, or violation of law or regulation. And so perhaps this is added so that restatements are not to be construed necessarily as an admission of guilt on the part of the manufacturer, but largely the definition of internal investigation as proposed in the May 2023 proposed rule is now finalized.
Yeah, so they weakened it a little bit, but my concern would be that they did that in response to comments to look responsive, but essentially these requests for restatement are a black hole, right? So the manufacturer would submit a letter to CMS saying, I need to restate outside the 3 years for internal investigation purposes. Here's what happened. CMS, please allow me to restate. And the agency can say yay or nay without really disclosing its reasoning. I find it curious. A restatement is a step toward enhanced compliance. And the fact that CMS is establishing hurdles to get to an enhanced compliance in the system is counterintuitive to me, but that's what the agency did. And so, yes, they threw in this little qualifier. I would still be concerned that CMS is discouraging and looking in a negative fashion at these restatement requests. So the last thing we'll talk about that the final rule implemented is a revision to the covered outpatient drug, or COD, definition. And that definition has two parts in the statute. There's the definition itself, which we'll simplify here and basically say if the product is FDA approved as a drug, so NDA, BLA, ANDA, and if it's regulated as a drug by FDA, is a covered outpatient drug. Then there's the limiting definition, which provides that if the drug is provided in the same setting and incident to certain enumerated services, one of which being inpatient hospital services, and if it's not paid separately from the service, then it is not a covered patient drug. And the way CMS has defined that or has implemented that throughout the history of the program is step one for the analysis is, am I a covered patient drug in the sense that I'm FDA approved as a drug and regulated as a drug? If the answer is yes, I have to do price reporting. I have to list the drug with Medicaid. But then whether a Medicaid rebate is due is determined by the limiting definition. So if the drug was administered together with the service and is paid together with that service and not separately, in that case, a Medicaid rebate would not be due on that utilization. So Danny, how is the limiting definition changing here? What is CMS doing differently now in the final rule?
Right. So in the final rule, CMS is expanding the scope of what constitutes direct reimbursement, which has the effect of narrowing, right, the limiting definition. And what that means is a more narrow limiting definition means a broader or more expansive covered outpatient drug definition, which means more drugs could be considered covered outpatient drugs. Interestingly, in the proposed rule versus the final rule, we do see that CMS has clarified what direct reimbursement will mean. And now the conditions that CMS puts for considering whether direct reimbursement is met is first, whether the drug is separately identified on the claim with its charge and units. Number two, whether the payment includes an amount attributable to the drug. And number three, if the drug is reimbursed based on a methodology described in the state plan. So it became a little more specific than what we had in the proposed rule. But yes, once again, direct reimbursement is being tweaked here, which has the result of narrowing our limiting definition.
Right. So the current state of play is if the drug is paid together with the service, the limiting definition applies and that utilization would not trigger Medicaid rebate. Now, in the new world, we have to look at whether there is direct reimbursement, and that can now include the drug is being paid together with the service, but the invoice or the billing document meets these criteria where the drug is identified separately. Maybe there's a separate amount. So like you said, if the limiting definition is more narrow, that means the utilization that's subject to Medicaid rebate is expanded. It also means for purposes of diligencing rebate invoices, it would be necessary now for manufacturers to get down to this level of the billing documentation to see whether this direct reimbursement standard was actually met. So I would expect to see complexity here, and especially this would apply for manufacturers that have drugs that sometimes are administered with the service and sometimes not. They could expect to potentially see more utilization triggering Medicaid rebates. Let's not forget that the 340B program, as a bolt-on to Medicaid, uses the covered patient drug definition in the Medicaid statute verbatim. The 340B statute doesn't have its own definition. It's just a cross-reference back to the Medicaid statute. And early in the days of the 340B program, HRSA and guidance indicated that it read the limiting definition the same way as CMS had read it at the time, which is if it's a joint reimbursement for the service and the drug, no 340B ceiling price requirement would apply. Now that CMS is changing its view of what the limiting definition means, we'll have to stay tuned and see how that flows through into 340B. I would not be surprised if 340B covered entities take this opportunity to subject more utilization to the 340B ceiling price requirement than has been the case so far. So having now walked through some of these highlights from the final rule, let's speculate a little bit about why CMS backed away from some of its proposals. Danny, what are your thoughts on that?
You and I have been talking about this a little bit, and I think there seems to be some strategic choices on the part of CMS on which proposals they finalized and which ones they did not. When we look at the new final rule, we certainly cannot know for sure, but we do speculate that the Supreme Court's decision in Loper-Bright back in June of 2024 may have had some effect on this. And as our listeners may know, Loper-Bright is a decision that was handed down by the Supreme Court recently, which overturned a longstanding Chevron deference doctrine, which essentially was a doctrine whereby courts generally deferred to agencies' reasonable interpretations of statutes that are ambiguous. So this includes CMS. And this standard now being eliminated means that courts may now scrutinize agency statutory decisions a little more closely. So it may just be that CMS, at the time that they were deliberating on which proposals to finalize, which to toss out, just thought strategically, okay, the Loper-Bright world is now different from the world we used to exist in, and we have to be more careful about what proposals we can actually finalize and which ones would not be subject to an immediate APA type challenge.
Yeah, we did a whole podcast on Loper-Bright and Chevron, so I would point you to that, but definitely speculation here. But it does seem that the proposals that CMS dropped were the ones where the connection to the statutory foundation is quite a bit more attenuated, such as the vaccine proposal. The statute says no vaccines, and here CMS was proposing to include vaccines in the Medicaid rebate program. So it stands to reason that the fall of the Chevron deference probably may have had some impact on this here. Final point before we wrap up, the timing of the effective date. Danny, when is this regulation going to become effective?
Oh, yes, this one's a good one. The regulation becomes effective as a general matter on November the 19th of 2024. And I think that this is an interesting tidbit kind of about the timing of this rule. CMS sets this effective date pretty much 60 days before the next presidential inauguration here, Chris. And I just don't think it's a coincidence. What do you think?
Yeah, so there's a whole bunch of legal research to be done here about what an incoming administration, assuming it's a different administration, can do to the prior administration's regulatory initiatives. And so we don't have to go into that here in too much detail, but essentially an incoming administration will try to pull down or pull back the regulations of the predecessor administration. And the longer something's been in effect when that handover takes place, the more difficult it essentially becomes to pull that down. So it stands to reason that the coincidental 60-day time window here is probably indeed not a coincidence. It's also very unusual for a legal standard to change in the Medicaid program not coinciding with the beginning of a quarter, because as we know, the rebates run on a quarterly cycle. So for CMS to step in and have an effective date in the middle of a quarter is highly unusual. There are other mechanisms through which regulations can be pulled back by incoming administrations. Again, we don't have to explore them in too much detail, but that's something to look out for. I question, though, whether this rule would be one that a potential Republican administration would focus on. My guess is this might not be at the top of the hit list, but again, it just informs why the 60-day period might be significant. So I think that takes us to the end of our discussion of this final rule and back to the question we had posed at the very beginning of this podcast, which Olympic sport is it like? So Danny, what do you think?
I've been thinking about which Olympic sport best captures the essence of this Medicaid final rule, and I think I have to go with fencing. Let me tell you why. Just like fencers, CMS and stakeholders here, like pharmaceutical manufacturers, are engaging in this intricate back and forth. There's the precision in interpreting complex rules, strategic thinking, involved in implementing changes, and let's face it, there's a fair bit of stabbing at times. Plus, both fencing and navigating the rule require quick reflexes and the ability to kind of anticipate the next move. So it's a high-stakes game where, in this case, every regulatory detail really counts.
Very nice. I like it also because it's almost like CMS was trying to use the broadsword in the proposed rule, and in the final had to be a little more careful and go back to fencing.
A little more blunted.
I would go here with one of the athletic sport, the 100-meter hurdles. And so in this case, I was thinking more the vision of CMS. They have these policy goals. They were trying to get this to the finish line, and they had to jump over these various hurdles, little constitutional questions, right? Because let's not forget the impact of the fall of Chevron, the purpose of the Administrative Procedure Act is to embody constitutional protections against government overreach, essentially requiring the government to follow due process. So from that perspective, I think it's a bit of a good outcome here that CMS didn't make it across all the hurdles with all of these proposals, because some of them were just beyond the pale of what would have been supportable. So that to me is a positive takeaway. As we said, there's still a lot of proposals that made it through that are not ideal, and we'll see how that plays out in practice. But definitely, I could see CMS trying to send the various issues down the 100-meter hurdles path, and not all the issues made it to the finish line.
That's a good one, Chris. Absolutely follow that logic.
So, Danny, that wraps up our podcast. And where are we going for the after party?
So, this is my favorite part, because a few weeks ago for my birthday, I went to a new contemporary French restaurant in Georgetown, and it's called L'Avant-Garde. And Chris, not only was the food amazing, but the service, the decorations, and the desserts were really good. And I think, honestly, if we just went and ordered from the dessert menu, we'd be happy campers. And I know you're a lover of sweet things, so I don't think you'll be disappointed.
Hey, dessert menu is what I look at first. So, hey, I'm in. Can't wait to go. Sounds great. Well, thanks, Danny, for being a moderator, and thank you to our listeners for checking out the Latham & Watkins Drug Pricing Series, which is part of our Connected With Latham podcast. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Spotify, or anywhere else you listen to podcasts. If you have questions or would like additional information, please email us using the links located in the show description. We hope you'll join us again next time.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.